Mr. Longwe is one of the state witnesses who is mentioned in the list of state witnesses in terms of Section 144 of the Criminal Procedure Act. The state, by simply including him in the list of state witnesses, gave out an impression that if circumstances were to arise that Mr. Longwe should come testify, will definitely call him. Therefore, you as a defense, stay away from him, because as of now, he's our witness. Now, the question that begs this court is, and that should actually trouble the court, my lord, very gravely so. Mentioning Longwe in the list of state witnesses, that is the person on whose probative value on what is happening on that video lies. It is only Longwe who can come and tell this court, yeah, no. Actually, the state does not even have to call that video. It does not even have to play that video. It simply has got to say to Longwe, Mr. Mngomezulu made these allegations to you that as and when this incident happened on the 26th of October 2014, you also got injured on your feet. Those are the allegations that Mr. Mngomezulu put to one of the witnesses. Do you agree with those allegations or not? And then he comes and tells this guy, I know, I never got injured today. Mr. Mngomezulu probably, I don't know, got that version from. That's the best evidence rule. Why is the state afraid? Or avoiding, really not afraid? Why is the state avoiding to call Mr. Longwe, my lord? Longwe Twala. Why is the state afraid? I have tried to come up with speculation and answers to which ingenuity may suggest. I can only think, my lord, and I'll be forgiven for thinking that the state is afraid that Mr. Longwe comes here. He says, no, I never got injured on that day. But beyond that, let me tell you how this incident happened. Actually, the firearm that was used on that day was not a 9mm, it was a revolver. That's just a speculation.
This can't listen to speculation.
Yes, thank you, my lord. But the gist of the question is, why is the state avoiding to call Longwe? The state does not say Longwe is no longer available. The state does not say that Longwe is untraceable. He is still there. That is the person on whose credibility and the probative value of what is depicted on that video lies, my lord. I would therefore strongly object in the strongest terms that that video should be played here and for Brigadier Gininda to come and opine on that video. What will he be saying? And in fact, the court has just indicated that it does not want to listen to speculation. All that Brigadier Gininda is going to say will be speculation, my lord. Thank you.
Yes, sir.
Sorry, my lord. May I just summarize everything?
Now let's the defense finish, and then you summarize for all three.
As the court pleases, my lord, two submissions really. The first one pertains to the applicability of Section 3, subsection 3 of the Hearsay Evidence Act 45 of 1988. And I say, my lord, with the greatest respect to Advocate Baloyi, that does not find applicability, my lord. My lord, we will have learned from the Baleka cases, the Singh, the Ramgobin, that video evidence is real evidence, and generally it is not considered hearsay. Hearsay will only arise, my lord, if in the video the persons depicted are making statements, and those persons are not available to come and confirm the statements that they made in that video. Otherwise, it is real evidence. There's no hearsay act applicable here, and I'll tell the court why. Mr. Mnisi has introduced, by way of submission, what we have seen in that video. That video is a 34-second video, my lord. It does not show any person uttering anything, or at least it is not audible what the utterances are being made. For that reason, my lord, I'll say the hearsay act does not assist the state in trying to bring Longwe's evidence via the back door, via Mr. Bailey, who says, in fact, what he obtained was not a video of 27 October 2014, but it's a broadcast of 10 October 2024. That was a rebroadcast, and it contains the subject matter of the subpoena that was served upon him by the state. He does not say it contains this footage. He says the subject matter of the subpoena. I don't know what the subject matter is. The state will clarify that for the court. I'm not privy to the subpoena that was served. It was never disclosed to us, my lord, and I don't think we also belong in the serving of that subpoena, my lord. Now, with video footage, my lord, it needs to be authenticated that it represents accurately what it purports to be depicting. Now, if only that it shows its action and not words, no oral utterances, I'm still standing, my lord, that without utterances, the Hearsay Act does not apply, my lord. Now, the second aspect, my lord, is, and just to concretize this point, is the one that Mr. Mnisi touches on. Mr. Longwe Twala is alive, my lord. In fact, my lord, if I go back in 2023, before Mr. Host testified, we received an email from Advocate Baloyi informing us that we must prepare that because they were going to call, amongst others, that Monday, Longwe Twala, Jack Buthelezi, and Mr. Host, Colonel Host. And about 10 was made later to say, no, prepare only for Jack Buthelezi and Mr. Host, my lord. I understand, my lord. I've been practicing for 100 years. The state is dominus litis. Why they decided at the last minute to withdraw Mr. Longwe to come and testify is their own prerogative, my lord. But the point that I'm making, he's still alive and kicking. And but what we have read in the media, my lord, he's sobering up from whatever is afflicting him. So he's a compellable witness to be called and testify on this aspect, whether or not he was shot at and injured on the 26th of October 2014, my lord. My lord asked me the other day whether I read Canadian law, and there's an important term that was mentioned there by one of the judges, and so Pinka was also in that judgment, which says, a witness like Mr. Gininda for this purpose is not going to assist the court and ourselves, my lord, to know that the person depicted on that video is Longwe Twala. I don't know Longwe Twala. The court does not know Longwe Twala. My colleagues, I believe, they don't know Longwe Twala. We are going to listen to the say-so of Mr. Gininda that this is Longwe Twala. That, my lord, in Canada has been held to be a supererogatory and unnecessary evidence by Sopinka. So, Advocate Baloyi is inviting this court to listen to the most superfluous evidence that will come from Brigadier Gininda, with the utmost respect. Brigadier Gininda is not going to assist the court in that respect, my lord. So I submit, my lord, and vehemently so as well, that this video should not be played in court until it's authenticated by the relevant people under oath, my lord. Not through the Hearsay Act that is not applicable, not through the superfluous evidence of a lay opinion of Mr. Gininda, my lord. Brigadier Gininda, I'm sorry, my lord. As the court pleases, those are my submissions, my lord.